Okay, I think we can get going. We have a few people already on and uh, all set to talk about and refresh your ideas and renew some ideas on the real estate condition report, or as we lovingly call it, the RECR. Um, so make sure that you understand the importance of the RECR, consequences of the record being wrong can be a huge liability for a seller. It's up to you to really stress the importance of this document to your seller. He can't blow it off or say, yeah, yeah, yeah. He has to realize that his liability is on the line on the accuracy on how he fills this out and understands the implications of it. This is not a real estate form. This is a Wisconsin state form. It is a Wisconsin law. So the mandatory use of it couldn't be more important. The idea that even for sale by owners have to fill out a real estate condition report. The only exception, I think, is families, selling to someone else in the family. But other than that, everyone who is selling their house must fill out by state law the real estate condition report. And what it addresses, it's saying to the seller, we want you to list every defect that you are aware of in your house. And the key word is, or key two words are aware of. There may be many things going on in a person's house that they're not aware of. There may be things that the person who owns the house is aware of, but thinks it's been fixed or has corrected it. But the important message for you to give to the seller is disclose, disclose, disclose any defect. And so on this page, what we have is the definition of a defect, and it really starts with on line 177 in the listing contract, and on lines 445 in the offer to purchase. It's gray. It's not perfectly black and white as the definitions, but these are it. Number one would have a significant adverse effect on the value of the property. Now, that's a very important thing, that if allowed this defect to continue in the house, it would lower the value of it. However, when an inspector inspects the property, the inspector cannot make any comment on the value of the house that he's inspecting. So that number one is not for inspectors to identify as a defect, but it is for a seller to identify as a defect. It is for a buyer to identify as a defect. So the effect on value is in the definition of a defect, but it is not considered by an inspector. If you have any questions about that little twist, make sure that you call me or Steph regarding that. But the inspector and the seller make sure that they have number two, that would significantly impair the health or safety of future occupants of the property. So if this defect is not repaired or replaced or remediated, it would affect people living in there by their health or their safety. And then also, if not repaired, if not repaired or removed or replaced, would significantly shorten the life. I can't get that on my. Would significantly shorten the sorry, that is blocking my line. Okay, So that definition of a defect is in the offer, it's in the listing contract. Make sure that you go over that with the seller. Do not, however, do anything beyond this in helping the seller fill out the real estate condition report. Don't give him advice on the whether something is a defect or not. Make sure that he looks at it. He can even consult um, an attorney if he needs to, but he can't consult you. You cannot help him in any way or advise him on how to fill it out or what a defect is. We can let them know that every question needs to be answered. We've already had a threatened lawsuit in our firm because an agent just didn't mark, or a seller didn't mark one of the questions in the real estate condition report. And the attorney used that as an incomplete real estate condition report and therefore was not effective. Every question needs to be answered, and you must tell that to your seller. We can stress the importance of disclosure. I try to scare my seller even a little bit about non-disclosure or mediated disclosure is very, very dangerous for a seller. It will to prevent future liability, and we've seen it happen. We've seen actual cases where the seller was held to liability because they did not fully disclose what they knew. It's up to the buyer to prove that the seller knew this and didn't disclose it. But non-disclosure is probably the most common lawsuit that we do face in real estate. So just try to scare your seller a little bit and just say, you have to disclose everything. And by the way, if it's a material adverse fact about the property and you won't disclose it, I am obligated to disclose it. So make sure you do not give the seller legal advice. Listing agents asking the seller to complete the record may give a general explanation of the chapters 709, excuse me, disclose law and the record, or the VLDR, that's the vacant land form. Agents can tell the sellers copies of these will be given to prospective buyers. And for instance, when they tour the house, we could have the record sitting out there for a prospective buyer to pick up and read through. It can't be secret, it has to be available. Agents can explain a buyer making an offer may be able to rescind the offer if the buyer does not receive the record. That word rescind is a very, very important word to a seller because they may think that they have an accepted offer. And if the buyer making an offer does not receive the real estate condition report, they can rescind their accepted offer. I don't want to buy anymore. I didn't get a record. If sellers have questions, however, about whether a specific item constitutes a defect, the seller should be referred to legal counsel. Agents should tell sellers that if they are uncertain, it may be the safest to explain the condition on the record, but if the seller wants a legal opinion, he or she should contact an attorney. So what the seller is aware of, if they're not sure, as they say here, whether or not it's a defect, the safest way is to go ahead and explain what it was. Put a yes there and explain. You may put a yes there and explain that it was a defect last spring, give the month or whatever, and say that it was repaired by licensed contractors or whatever. So you can put that explanation in there if there's something that the seller is really uncertain about. But the best way is to get advice from an attorney, not from you. your hands off on this 100%. Disclosing defects as a licensed agent. So as I referred to just a little while ago, if the seller is sort of hiding a defect or downplaying a defect, trickle of water as opposed to flood, it is your responsibility as a licensed agent to report the material adverse fact. So it has to be material to the transaction. It has to be adverse, it has to be a bad situation in the house, and it has to be a fact. And there is a form, I don't have it in this presentation, but there's a form in the WRA form library that is for the agent to fill out, explain what the material adverse fact is, and then make it available to everybody involved in the transaction. Sometimes the seller doesn't like that, but that is an obligation and a requirement of your license that you must disclose, that you have to disclose any conditions that you see that he is not disclosing. Compare this against the real estate condition report. If it is marked, say, no on the real estate condition report is not a problem, but you have seen that it is a problem. He has probably even told you that it is a problem.
Hey,
Hi.
your slides aren't moving with you or something.
They keep jumping. Yeah.
Can they hear? Well, do you have a? I should have brought my computer. I just want to make sure that they.
Everybody, can you tell me whether or not you're seeing the slides advance or not?
Maybe open up chat, see if. Oh yeah, your screen sharing is paused. That's why.
Oh,
So
good.
hit share. And then, yep, and then hit share here.
Okay.
It still says paused. Let's try that little arrow. It's going down. Oh, hit stop share on that. And then go hit share again here. And then you want to go to your Safari and hit share. And then where is it in here?
What?
Or no, your slides. Why does it say paused? Hit stop again on here.
I mean, they're up there.
Where
We're working on it.
is it in one of these or did you have it in like Google or something?
It was in the share in here.
But where, so this is gonna say like what's part of the screens you want to share.
Okay.
So if that is gonna share from Safari, but is the slides or is it this?
Oh, here. What about this?
Possibly, yeah. It says, but then,
Weird.
so now you're sharing this portion. So
Mhm.
let's go to Google Drive and open up and then, is it, yep. So you double click this. And then, slideshow. And then now it says your screen sharing is
It's
paused again.
paused.
Resume, hit this resume button.
Okay. Where? This one?
Nope, the play button above it, right there.
Gotcha.
No, it still says paused.
What about that little mark?
No, that's secured. Hit this arrow again. I'm not sure why you're having issues. Because it shows right there.
Mm-hmm.
Shit. do share here again. And we're just gonna share your entire screen. So let's go
Here it
advanced.
is.
Well, that's in Safari, but I mean, it'll probably just do the same thing.
Okay.
Um, go to advanced, and then can you do the whole screen? Nope. Should be an option, entire screen here. Let's share. All right, so let's ask him again. Can they see your screen?
Can you see the screen now?
Now we
Just
can, yeah.
You
Okay.
can. Great.
Sorry.
Yeah.
No
Thank
worries.
you so much, Willis. Yeah, I was just clicking along thinking everything was fine. Okay, so where we are basically is this is, as you can see, an overview of the record and why it's important and why it's your responsibility to help protect your seller from liabilities, from not telling. And if you are totally aware that he is hiding something or not giving it the fullest extent, it is up to you. It's a requirement of your license to disclose it as a material adverse fact. And there is a form in the WRA form library to fill this out and then to have it available to anybody that is showing the house, anybody that is ready to look at the house in any way. So if the seller has filled out um, the seller has filled out a record, but new information comes to him. Now, this happens all the time, and this is where Steph and I get a lot of questions. Something happens or something is made aware of that wasn't made aware of during the filling out of the record. But now the accepted offer is in place is one thing. If there's no accepted offer in place, there's another way to do it. So if you don't have a accepted offer, you can go in and do an amendment to the real estate condition report and provide any new information that they have discovered. But if you have a accepted offer, please do not go in and amend your real estate condition report because that gives that buyer with the accepted offer a right to rescind his offer. So if there's no offer on, go definitely with the new information and amend your offer. Or excuse me, amend your record. I hope that's clear to everybody because that's really important. Now to get rid of this stuff. Um, So a seller can provide a previous inspection report to a new buyer or amend the record and fill in a new record. I like to amend the original record so that there's a paper trail of what's happened since you put your property on the market. But if they have, you can add the previous inspection report to the record, or just take the things that are new that you didn't know that were discovered in the inspection report and amend the record for those things. So the seller per lines in the offer to purchase shall be given an inspection report whether or not any defects were discovered. The seller has the right to provide this report to any new buyers. So sometimes, I don't think there are many times, but sometimes some agents think that, well, my buyer's okay with the report, my buyer's okay with the house, my buyer's okay with the inspection, and so we're not sending over the inspection report. That's a no-no. They have to send over the inspection report whether or not any defects were discovered. It's written right in the offer that the seller has the right to provide this report to any new buyers or just amend the record. Any questions about that? Because we seem to get a lot of questions when people are involved in this part. What do I do? Do I have, can I attach the real estate condition report? Can I attach the inspection report to the real estate condition report? Or is that private? Does the seller doesn't have to share that? No, the seller either shares it by amending the report or shares with a whole inspection report to the buyers. Any questions? So here's the starting copy of the starting page of the real estate condition report. Condition report concerns the real estate property located at, and they put the address in the city, town, or village, in the county of, and then the state of Wisconsin. This report is a disclosure of the condition of that property in compliance with the section 709.02 of the Wisconsin statutes as of, and you put today's month and day and year. It is not a warranty of any kind by the owner or any agents representing the parties, representing any party in this transaction, and it is not a substitute for any inspections or warranties that the party may wish to obtain. Now that's in bold print and it's important. So make sure that when your seller is given the real estate condition report and this is what they are about to fill out, make sure that they understand this paragraph. A buyer who does not fully receive, not receive a fully completed copy of this report within 10 days after the acceptance of the contract of sale or option contract for the above described real property, so 10 days after acceptance of the offer, has the right to rescind that offer, provided the owner is required to provide this report under Wisconsin statutes. So if he doesn't get the real estate condition report within 10 days of acceptance, he can pull out his offer, rescind it. I knew how to get rid of this. So this is also right on the first page, and it is all the descriptions of words, definitions of words, and the using of this condition report. It is for the seller to read over. You cannot give any advice on it, but make sure that he reads every bit of it. Defect means a condition that would have significant adverse effect on the value of the property, that would significantly impair the health or safety of future occupants, or that if not repaired, removed, or replaced would significantly shorten or adversely affect the expected normal life of the premises. So they're repeating right there the definition of defect. And this form, the owner means the person or persons, entity, or organization that owns the above described real property. An owner who transfers real estate containing 1 to 4 dwellings, including a condominium unit and a timeshare property, by sale, exchange, or land contract is required to complete this report. Now, here are the exceptions. Many times people think they're exempt when they're not. So it's right here printed on the real estate condition report what the exemptions are. An owner who is a personal representative, trustee, conservative, known as, or a fiduciary appointed by or subject to a supervision by the court, and, this is important, who has never occupied the property transferred, is not required to complete this report. So there it is, black and white. Who is exempt? an owner who transfers property that has not been inhabited or who transfers property in a manner that is exempt for real estate transfer fee is not required to complete this report. So an owner who transfers property that has not been inhabited, that means never been inhabited. Doesn't mean that hasn't been inhabited for a while or sitting vacant or something. It's never been inhabited, which usually means new construction. Or who transfers property in the manner that is exempt from real estate transfer fee, that usually means within family, transferring the property. An owner represents that to the best of the owner's knowledge, the responses to the following questions have been accurately checked as yes, no, or non-applicable. The NA means non-applicable to the property being sold. It talks about a waterfront property and there's no waterfront, that's non-applicable. If the owner responds to any question with a yes, the owner shall provide in the additional information area of this form an explanation for every yes. So there are blank lines at the bottom of each section. If they mark yes on any one of them, they must give a explanation on those lines. If the transfer is of a condominium unit, the property to which this form applies is the condominium unit, the common elements of the condominium, and any limited common elements that may be used only by the owner of the condominium being transferred. And then I can't get to that. So this is the bottom of the next page, and it shows where requires owners who prior to an acceptance of a purchase contract obtain information that would change a response on this report to submit a complete amended report. Amendment to the previously completed report to the prospective buyer within 10 days. So the owner certifies that the information of this report is true and correct to the best of the owner's knowledge. Make sure that they take that to heart, that this is an acknowledgement of truth. If there's anybody supplying any information, maybe you have a well report or you have a drain tile report or something like that that certifies, that the owner certifies that the person supplying the information on which the owner relied for his report, that the information is true and correct to the best of the, jeez. Anyway, I'm so sorry about this mess up with these slides. And then at the very bottom of the form, last page, bottom line is where the seller signs. And remember, this is not to be used on the seller as certifying these things. It's just an acknowledgement that they received it, period. So he acknowledges the receipt of this report and then he signs his name. So you can say to the seller, this doesn't mean you're accepting all of these situations. It just means that you acknowledged receipt of this. Now, I don't have any more slides, but I sort of botched this up because of the transferring of the slides in this and not working very smoothly, and I do apologize for that. And I hope it doesn't diminish the importance of using the real estate condition report, of making sure that you are not exempt. There are only few people exempt, a few conditions. One of the things, a personal representative is exempt, but if a personal representative, say, is a child or a grandchild of the seller, but lived there when he was young, that personal representative is not exempt. So if they live there at all during their lifetime, they are not exempt. A seller who is selling the property and hasn't lived there Uh, if he is the seller, he is not exempt. He must fill it out, and he can say, well, I never lived there. I just remodeled it and put it back on the market. They are the owner, they are the seller, and they are not exempt. They must fill out the condition report. That's probably the biggest misunderstanding in this. They say, well, I never lived there, so I don't have to fill this out. That's not true. And again, remind the seller that this is a Wisconsin statute, that this is not a real estate form. And it is very much for the protection of the seller to disclose, to disclose, to disclose. Now, are there any questions about this?
Joan, I have a question.
Sure, go ahead.
What, in the instance that you are hypothetically, you're selling your grandparents' home, you're going to be the listing agent, but you've also lived there at some point in your life as the agent. What do you do in that situation? Because technically, as the listing agent, also related to the seller, you aren't the seller in that instance. But I mean, what do you do if you've lived there in the property beforehand?
But you're just an agent. You're not a representative for the sale or anything.
Oh, okay. That makes perfect sense.
Okay. I mean, if you're just the agent, you can state in there that you are related to the seller, and that you're licensed in the state of Wisconsin. So you have to pick up on that relationship and disclose that in the listing in MLS
Okay.
and in the offer. But it doesn't affect how you fill out the condition report.
Understood. Thank you.
Okay. Any other questions about the record? My former manager a long time ago used to say this was the most dangerous document in our of all of our documents. And a lot of it is right. I mean, if you inadvertently give an advice to your seller and say, well, I don't know that that's a defect, or I'm not sure that's a defect, or this is what I would say in this situation. You are helping the seller fill this out. And if it snakes back through an attorney, as some of these have, you can be held liable, and Keller Williams would be held liable. So, as I said, this is a dangerous one if you don't follow the rules. It's a dangerous one for the seller if he knows about something but won't disclose it. He is far more in trouble by not disclosing something and purposefully not putting it in, or knows about it and is not putting it in the report or anything. And the rescission times are important. If he doesn't get that real estate condition report in the 10 days after the offer is accepted, the buyer can walk. If he gets it but doesn't, an amendment is made to the real estate condition report, and the buyer, the accepted buyer at this point sees the amendment of new, he can rescind his offer. So don't amend your offer if you have an accepted offer on the property. Don't amend the real estate condition report if you have an offer on the property. Anything else? Well, I have nothing more. In tomorrow's meeting, I'm going to talk about the refusal to fill out the real estate condition report form. And I'll have a copy of that up and be referring to that, because there are some sellers that absolutely, whether they're exempt or not, refuse to fill out the form. Okay, that's in tomorrow's meeting.
Thank
All
you,
right.
Joan.
Hey, everybody. Yes.